Case People versus Jade Lathan.
Case on behalf of the people.
Overwater Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
This is where the law shifts focus completely because this is no longer about guilt or innocence. It is about competency.
Your Honor, I did attempt
Mr. Overwater, while she's given that, is this the person that you know to be the...
If the court believes she does not understand what is happening, everything stops, no trial, no progress, nothing moves forward.
Individual named in the complaint. If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade, Ruth, and Lathan.
But here's the real twist: what happens when someone claims they understand everything yet speaks in a way the law cannot recognize.
And beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing.
I'm not
pursuant
asking
to the
for
statute.
anything, and that's coming from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
This is a major red flag in court. Rejecting your legal identity does not change the case, only makes things more complicated.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay. I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for June 6, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Even her own defense is raising concerns because when a lawyer questions competency, it means something is seriously off.
These people versus Jade Lathan.
Mr. Canapa for the people.
Defendant Overwater Assistant Public Defender on behalf of Ms. Lathan, who's approaching. Ms. Lathan, would you state your name for the record, please?
J. Ruth Bay, beneficiary of the principal.
Your Honor, I have spoken with Ms. Lathan several times. We've reviewed some of the discovery. We are looking into some potential resolutions. I'd ask to adjourn the probable cause conference. I would ask for more than 2 weeks.
August 29th, 2024, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Does call the case. People versus Jade Lathan.
Defendant Overwater Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to...
The judge is being direct here because what she is saying does not exist in legal procedure, and the court cannot operate like this.
Speedy trial, and this is the 5th time I've made an appearance for this in the case of this case in the court of law since February 2024 for the arraignment since the arraignment when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condolis 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I have also not disturbed the peace, and I have on file with public defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been well-behaved, a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth, and I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied two main sources of evidence for my case via my personal FOIA request that would have easily shown.
And just like that, the decision is made competency evaluation ordered because the court cannot move forward without clarity.
My innocence. These two things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied.
What looks like a normal hearing is about to turn into one of the most unusual courtroom moments you will ever see.
Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Jarrell. Please state your name.
Gerald. Okay. And where are we on his case?
Your Honor, we have not had contact prior to today. I think the number we have for you may not.
I don't have a phone. So whoever gave you a number was invalid.
Okay. So I'll need to figure out a way to get in touch with him so we can go over the case together. If I give you my number.
What is?
You have a P.O. box?
I don't have a phone. I have I'm just gonna use a P.O. box, I think.
Okay. Do you have an email address?
No. I'm on his radar. I don't use electronics.
All right. So you guys are going to be trying to figure out a way to make contact with each other, right? So.
Yeah.
Okay. So the reason I say that is let me just do this. Let me give you a little bit of time so that I'm going to adjourn this out to September 4th, 2024, 9 a.m.
What's the holdup?
Oh.
It's trespassing.
Pardon?
I don't understand what the holdup is. It's trespassing.
What do you mean what the holdup is?
This is it's an arraignment, right? Or a preliminary exam?
No. You're not charged with a felony, so it's not a preliminary examination.
Right.
You were arraigned in this on July 24th.
Mm-hmm.
they set this date, your attorney hasn't been able to talk to you about the cases at all.
Okay.
So I'm trying to give, I mean, I can set it for 2 weeks out,
Yeah,
but the problem,
I'm tired of the state. I'm ready to leave this state as soon as possible. It's trespassing. I could technically leave and you guys could issue a warrant as long as I don't return. You can kiss my ass. This is
you know what? No. I'm gonna tell you what. You don't come in, you don't. Okay, that's contempt. That's 93. Keep going. That's another 93. That's another 93. That's another 93. That's another 93. That's 6 93s consecutive. It does call the cases of the people versus Daryl Jarrell.
Ron Brown appearing on behalf of Daryl Jarrell, Your Honor.
Good afternoon, Your Honor. Daryl Jarrell.
Defense counsel has filed an emergency motion to attempt to purge the contempt in this matter.
You have.
And I first give the floor to my client.
Pardon?
I'm giving my client the floor.
Your Honor, there's no excuse for what I done, man.
So we're dealing with misdemeanor trespassing, normally a low-level charge. Nothing here screams major jail time, at least not yet.
I lost my composure and I directed my frustrations at you. I apologize for being disrespectful to you and your court and wasting time, the people. Hopefully you accept my apology and reconsideration of the time you've sentenced me to. Thank you.
Your Honor, we have referred him to our aimed social work division to help him work through in some of the personal issues that he's going through that culminated in his outburst in court. You've been a judge for a very long time, set a very high bar for people as they appear before you. I think we communicate differently. Some people, even though it's socially inappropriate, use profanity, and profanity can be used as an attention getter. And I think it got the court's attention, but he's in need of services.
Oh, he did.
He's in need of services, Your Honor. He's in need of services, and we're trying to sort through a plan to present to the court. If you would accept his humble apology to help him move the cases forward.
Anything from the people?
Well, Your Honor, we were all present for it. I had a chance to review the video. It's actually worse than what the court noted. I'm sure the court's has seen the video, but it was worse than what the court noted. I will leave it to the discretion of the court, but if there's going to be a modification or change of the sentence imposed by the court, I would certainly like there to be a plan in place for Mr. Jarrell.
Mr. Jarrell, what was going on with you?
Well, there's a lot of issues that I'm under currently. One, I'm unemployed.
And here's the first red flag. No contact between attorney and client. That is a serious issue because effective defense starts with communication.
I can't obtain a driver's license. Without those, it's hard to provide for yourself. The charges, once we get into it, you'll see that they're frivolous charges. They should have never been brought to the court's attention. They're minute trespassings that aren't even trespassing. I used an easement for one, and the other one should have been dismissed. Just frustrations, man. There's no excuse for what I've done. You wanted an in-depth look. I shared some things. I mean, it falls on me, man.
No, it does.
No phone, no email, completely off the grid. That might sound unusual, but legally, it creates a huge barrier preparing any defense.
He realizes that this case, many other people are watching, and how the court handles it. We're hopeful that others won't use this as an example to act out as well.
Well, but from the very beginning, the one thing that, as Mr. Brown correctly points out, I've been doing this a minute. And, Mr. Jarrell, you were in my court, and I watched you because you were sitting in the back. And you were sort of a dichotomy of things for me. Because as you sat back in the back of the courtroom, you sat there very respectful. You had your ball cap on. You came through, you took your ball cap off, you sat in that back row, just patient as all could be. When you came up, you again, initially it was fine. You were maybe upset by the charges, but a lot of people were like that.
Right.
It was going fine, and I could overhear, just so that you understand what I was trying to do, I overheard, as you were talking to your attorney, that you didn't have a phone.
Right.
You didn't have email. And more than anything in the world, I was worried that you weren't going to be able to have adequate time. I would have just normally set it 2 weeks out, then whatever. And I was trying to give more time, not to delay it,
Yeah.
but to try to make sure that if you had to get in touch with Ms. Pirney by letter, you guys had to do that or do whatever,
Yeah. See, I was thinking
that
the other.
there be time for that to happen. And that seemed to aggravate you, but I think, when I look at it, you were aggravated because you thought the system was kind of dragging out.
Good.
But I was doing that for your benefit.
My apologies. I'm again
This is where frustration starts boiling. But here's the problem. Court procedure doesn't speed up just because a case feels simple.
misunderstood.
And so then when you wanted me to, then you wanted it done sooner. So then I said, okay, I'll move. I just said, well, I'll move up to date. I didn't know it wasn't going to be helpful for you, but what the heck? And then that's when you went off. I had people go off in front of me before. Doesn't bother me. It's going to happen, I guess. But you just got yourself worked up to the point that as you were headed down and out, I'm just thinking, you're not. I don't know why you want to battle. It's a battle you can't win.
Right. Silly me.
Yeah, silly, stupid. There's a lot of words. Maybe start with that because it didn't make any sense.
No, not at all. You're right, man.
And I'm going to tell you something. I'm not saying this to embarrass you because you're in good hands with the folks at the public defender's office. You need a break, right?
Yes, sir.
You need something to go in your direction.
Yes.
Yeah. And it seems everything, you can correct me if I'm wrong, everything you had been doing, none of it was quite working out. Trying to get rid of stuff. This is one of the things you wanted it done and gotten rid of so you could try to move on to that next thing.
Absolutely.
And I'm not saying this again, I'm not saying this to embarrass you, but sometimes things get tough. You get yourself wound up. You get to a point, and then for a brief moment you regret it. You're not sure where to head. Right?
Yeah, sometimes.
And I think even that day, for a brief moment, you regretted what had happened.
Absolutely. As soon as I said it.
And there it is. The moment everything derails. One emotional outburst. And suddenly we're no longer talking about trespassing.
But I was fueled.
And it's because when you got back there, and all of a sudden that door shut behind you and locked up, you realized something.
Oh, man.
Yeah. And as it was described to me, right or wrong, you were sort of laying there on the floor crying.
Wrong. I was sorrowful.
Look.
I may or may not have.
No,
I don't
listen,
recall.
Just listen. There's no embarrassment there.
Mm.
There's not. I got it reported to me
Right.
because I was worried about you. I didn't. Nobody was trying to say to embarrass you or do anything. You had gotten yourself to a certain point. Something got out of control. You took a circumstance that was kind of bad, made it even worse.
Those 93s the judge is stacking, each one represents a separate contempt charge, each punishable by up to 93 days. This escalates fast.
Now you have to figure out how to get out of that.
Right. Absolutely. Yeah, for sure.
Okay. You had left here that day. You don't have a place to stay, do you?
No, I'm currently homeless.
Yeah.
The Delana Center.
Pardon?
The Delana Center.
But are you there most of the time?
They have a waiting list period.
Yeah.
So as long as you continue to check in, I think they do a triage. Let them know that you're interested in a room there. They'll continue to screen you, and when one comes available, they'll offer it for housing. Until then, you sleep wherever you can, couches, wherever.
Quick legal breakdown. This is called direct contempt. It happens right in front of the judge, and it can be punished instantly. No separate trial needed.
Tents, bridges, parks. As long as the cops don't push you along,
So the reality is you didn't have a place to go, right?
Oh, no, I don't have a place to go. No.
All right.
Judge, he's even sleeping.
Pardon?
He was sleep deprived. He's sleeping. He's got a roof over his
probably
head.
was sleep deprived a little bit too. Man, I couldn't stop falling asleep. Did you notice that? Couldn't, man.
I just thought it was my relaxing voice and personality. Mr. Allen, actually today, you look a whole lot better than you did that day.
Thank you. I feel better too.
Before you came in, when was the last time you ate?
I ate probably the day before.
So you hadn't eaten that whole day.
No. I actually went to eat, but I didn't have enough time to jump on the bus and come back, so I skipped it. I think I may have had some donuts for breakfast, though.
Okay.
I think I may have.
What do you think I would do with you after what you did?
And you can do anything you want with me, Your Honor.
Oh, I know I can.
What I would like you to do for me is to let me go, and we'll have continued scheduling of the September 4th date. And you'll see that I've told you the truth about the charges that are pending. They'll probably even get thrown out by then.
Pardon?
Once the prosecutor reviews them, they should probably get thrown out.
Well,
This is a critical shift, accountability. In court, a genuine apology can sometimes open the door to reduce penalties, but it's never guaranteed.
probably you're about to try to make another mistake. And that is you're trying to practice law, even though it's about your case and you don't have a law degree. Why don't you leave it to the experts that are around you?
And,
Yeah.
sounds good.
I think he's suggesting that you suspend or hang it over his head. Contempt, if
Okay,
not
was that we sent him in?
purge, Your Honor.
I can't just let you walk away from it. What you did is, so that you understand, this really isn't about you or me. It's about you.
Yeah.
But it isn't about me. You can say all those things you want, but the one thing in the past 25 years I will tell you, I do not let people just disrespect this institution and walk away.
Right.
It just won't happen with me, and I'm sure Mr. Brown has told you that. I just don't.
Okay.
I understand, however, and balance that against sort of where you are and what you're trying to do. So we're currently set for September 4th at 9 a.m. What I'm going to do regarding the contempt, I'm going to work it this way. I will grant to a certain extent the motion, and I'm going to reformulate the 550.
Now we see the bigger picture. Unemployment, instability, frustration. This isn't just about behavior anymore. It's about circumstances.
558 days that you talked yourself into. And when you're back there thinking, think about this, how you took a case with a maximum 30-day sentence and parlayed that to 558 days.
Right. Oh, goodness.
So what I'm going to do is take the 558 days. I will indicate defendant is to serve 93. I will give him credit for the 6 that he's been in and suspend at this time the balance.
Thank you.
When we come back, so it's down to 93 now. When we come back on the
Important insight. The judge was actually trying to help by giving more time, but miscommunication turned that into perceived delay.
4th, I'll consider whatever else I might do regarding that sentence.
Thank you, Your Honor.
Whether or not you serve the rest of it is going to be dependent upon your behavior, how you come into court.